Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Does your license need saving? Do the wise thing. Call Wise Man Lawyers. Don't face that court alone. Let the Wise Man team get you back on the road. Does your license need saving? Do the wise thing. Call the Wise Man team at Wise Man Lawyers.
Alright, today I'm at Pine Rivers Magistrates Court. Client was charged with mid-range drink driving, reading at .147. The mid-range bracket, it starts at .1, goes up to .149, and high range starts at .150. So obviously, with my client having a reading at .147, he was almost high range, but not quite. Had he have not lost his licence for other reasons in the last 5 years, he would have been eligible to apply for a work licence, given that he's under .15. The cut-off for work licence applications is .150. So if you haven't lost your licence in the last 5 years, you're the holder of a open Queensland licence, and your reading is below .150, you can apply for a work licence. Just simple application doesn't equate to a granting of an application. You've still got to explain or prove that you're a fit and proper person and that you will suffer severe financial hardship if you lose your licence. But what I'm getting at is my client had already lost his licence for demerit points in the last 5 years, so that made him ineligible to apply. But had that have not been the case, with a reading of .147 as high as it is, still would have been under the the work licence cut-off of .150. But as I said, he had lost his licence in the last 5 years, so my job was, instead of getting a DUI drink driving work licence, was one of getting the disqualification down as low as possible. Worst case scenario for mid-range is a 12-month loss of licence, but magistrates do have a general power under the Penalties and Sentences Act to give a lifetime disqualification. But in realistic terms, worst case today was 12 months. Mandatory minimum was 3 months, but as I said, the mid-range bracket starts at .1, meaning the closer to .1 you are, the easier it is to persuade a magistrate to give the minimum. But the further past the .1 you are, the harder it is. And the closer to .15 being the start of the high range bracket, the harder it is as well. So just put it in perspective, had my client have been .150, that would have been high range, and the mandatory minimum is a 6-month disqualification. So he was almost at that point, meaning had he had a little bit more alcohol, it would have been a minimum 6 months today as opposed to a minimum 3 months. As far as preparing goes, I asked my client, as I do all of my clients, to attend a reformatory course setting out, what happens if you drink drive, what can go wrong, the injuries and deaths that you can cause, etc. I generally draft affidavit materials for my clients to sign, trying to explain to the magistrate what they learn at the course. I also provided him with a template to give his referees to guide them through what the character references that I wanted him to obtain needed to cover and who they needed to be addressed to. I met my client at court this morning, ran through the court procedure and what I was going to say before we went in, because I don't like clients to see and hear things for the first time as they're happening. It's already stressful enough as it is. Short version, as I said, I made lengthy and substantive verbal submissions about the difficulties that he'll suffer while he's off the road, and that why in this instance it'd be appropriate to give a disqualification that's perhaps not as lengthy as one which may be given to someone that wasn't being adequately represented. Going in, I said to my client, there's no way in the world we're going to get the minimum 3 months with that reading, but I'll try to get it down. Well, I'll try to get it to 3, but realistically, if we can get 4 or below, it's a very good outcome for a reading of .147. Short version is, I was successful in persuading the magistrate to give no more than 4 months. I'm not going to pretend that I didn't push for the minimum 3 months. I did push for that as a starting point, but going in, I did explain to my client that that was me well and truly lowballing it, and it's an unrealistic expectation. Whereas if we can get 4 or less for that reading, it's a very good outcome, particularly given that he was only a tiny amount away from being high range, which would have had a starting point of 6 months. So, as I said, 4 months disqualification, modest fine, client's happy. I'm Andrew Wiseman. Thanks for watching. Hi, I'm Andrew Wiseman from Wiseman Lawyers, Queensland's only truly dedicated drug, alcohol and traffic offence law firm. If you face loss of licence, loss of vehicle imprisonment or anything in between at any court in Queensland, we can and will help you today. This is our specialty. This is all we do. Give us a call, 1300 947 352. I look forward to helping you resolve your issue today.
Don't face that court alone. Let the wise man team get you back on the road. Does your license need saving?